Hello and welcome to Topic 7, Lecture 1. And in this topic, we're going to start the presidency, which is covered by Chapter 13. So what are we going to be covering in this lecture? Well, first we're going to take a look at Article 2. Article 2 is the article in the Constitution that establishes the presidency of the United States. And then we're going to go in and take a look at different types of presidential power. There are different categories of presidential power that your textbook talks about. And so we're going to learn about the difference between expressed powers, implied powers, delegated powers, and inherent powers. So let's go ahead and get started. So what are we going to be covering in this lecture? Well, first we're going to take a look at Article 2. Article 2 is the article in the Constitution that establishes the presidency of the United States. And then we're going to go in and take a look at different types of presidential power. There are different categories of presidential power that your textbook talks about. And so we're going to learn about the difference between expressed powers, implied powers, delegated powers, and inherent powers. So let's go ahead and get started. So Article 2, Section 1 is the section that actually establishes the office and the methods of selection for the President of the United States. So keep in mind that prior to the ratification of the Constitution that was written in 1787, there was no President of the United States. There was no federal executive branch, and there was no federal judiciary. Because in the Articles of Confederation, it only had one federal branch of government, and that was the legislature. And so the new Constitution creates the office of the President of the United States, and we find that in Section 1 of Article 2. And so in Section 1, it basically says that there will be a president and a vice president of the United States. Keep in mind the reason they didn't want a president under the Articles of Confederation is the goals of the Articles of Confederation was to give all the powers to the states and really minimize the role and the power of the national government. And so they really thought that, hey, if we create like a president of this new nation, that president will sort of act like a king and will abuse their power. And they're like, hey, what better way to prevent the abuse of power than to not have that office? However, one of the failures of the Articles of Confederation was the fact that there was not a single person that represented the United States and a person that you could hold accountable for the actions of the United States, at least in part. And so there was a real concern at the Constitutional Convention that we really do create this office, and that's why it's created. So Section 1 establishes that there will be a president and a vice president. It also tells us what the terms of the office are going to be, the qualifications, and the oath. Let's talk about the qualifications, and we don't need to talk about the oath, but the presidential oath of office is actually in Section 1 of Article 2, so you can take a look at that on your own time. The qualifications of the presidency are sort of similar to the qualifications that we had for the House and the Senate. It's just that the qualifications, they're a little bit different. One major difference is that the President of the United States needs to be a natural-born citizen. That's not the case for the Senate and the House. Now, it is possible that if you are not a natural-born citizen at the time of the ratification of the Constitution, you actually could have still been President of the United States because they said that you were either natural-born or a citizen at the time of the adoption of the Constitution. So if you're a big Alexander Hamilton fan after watching Hamilton, you might ask yourself, could Hamilton have been the president of the United States? Because he wasn't born in the United States. He was born on the island of Nevis in the Caribbean, part of the West Indies. But because he was, at the time of the adoption of the United States Constitution, a U.S. citizen, that he could have been president of the United States. But there were other reasons, if you know from watching the musical, why that was not a possibility. It also says that you have to be 35 years old, so older than the qualifications for the House, 25, the Senate, 30. And that you have to be a resident, you have to be a citizen, or and today a natural-born citizen, but you also have to be a 14-year resident of the United States. So you could be a natural-born citizen and then leave the United States and live abroad for a very long period of time. And if you came back to the United States, you would not be qualified to be president of the United States unless you established residence here for for 14 years. The term of office that was established in Article 2, Section 1, it's a 4-year term. But there was nothing in the Constitution that said that that there were a limited number of terms that you could serve. It was just basically the norm that a president would serve no more than 2 terms, because that is the norm that George Washington, the first president of the United States, set. And so he served 2 4-year terms. He could have run for a third, but he said no. He wanted to establish the precedent that a president shouldn't serve more than 2 terms. And that was a precedent and a norm that was followed until Franklin Delano Roosevelt. And so Franklin Delano Roosevelt he was elected to 4 terms of office, starting his first election in 1932, and then he was elected to a 4th term in 1944. And it was at that time that we amended our Constitution to add the 22nd Amendment. And what the 22nd Amendment says is that a person can only serve 2 4-year terms within the presidency. Another thing that Article 2, Section 1 does is it determines how the president is going to be selected. And there was a lot of discussion at the Constitutional Convention about how the president should be selected. As you might recall from the Virginia plan wanted to have Congress select the president. And that's kind of like the parliamentary system, right? The parliamentary system is that you elect members to a parliament, and then the parliament selects who the executive is going to be, selects who the prime minister is going to be. And so they considered that at the Constitutional Convention, and they said, nope, that they didn't want the president beholden to the lawmaking branch. Because again, the framers really wanted to have a robust separation of powers and checks and balances. And if the president was beholden to Congress because they're the ones who selected them, it would mean that too much power would be consolidated into the hands of both the Congress and by default into the presidency. They also did not want the people to have a direct election for the president. They didn't want that. They realized that given education levels at that time period, it probably wasn't a good idea. The framers were elitists and they wanted elite people to select who the president was. Also, if you were running for president and you had to campaign, they also saw that was kind of below the dignity of the presidency of the United States. And so they came up with a compromise. And that compromise is what is known as the Electoral College. And so the Electoral College, and you're going to be learning a lot more about that this week, but not in this lecture, that this week our discussion is about the Electoral College. And so you'll be learning about how the Electoral College works, and then you're also going to be reading articles about whether to keep it or get rid of it. But in short, the Electoral College is a way where states select electors, and then the electors are the ones who determine who the president of the United States will be. It used to be that the electors were not directly elected, but they were selected by either parties or they were selected by the state legislature. And so again, it was sort of an elitist group of people who were selecting the president. But today, the electors are determined by the popular vote in the states. But still, the Electoral College is the entity that determines who the president of the United States is. It also gives an advantage to gives an advantage to small states. So each state's Electoral College votes are determined by the number of members of the House that they have and the number of senators that they have. So for example, Wisconsin gets 10 electoral votes because we have 8 members of the House and 2 senators. But that means that Wyoming, who has 2 senators and 1 member of the House, they get 3, right? So small states, their say in the Electoral College is magnified. And so you'll be debating whether or not we should keep or get rid of the Electoral College in this week's discussion. So Section 2 and 3 of Article 2 tell us about the powers of the presidency and also the duties of the office of the presidency. So Section 2 tells us about the powers of the presidency. When we think about the difference between powers and duties, Powers are that the president has the authority to act, and it's granted to that person through the Constitution, but they don't have to act. So, for example, that the president has the power to veto a law, but he doesn't have to veto a law, right? He has the authority, he or she has the authority to do it, but that they can use their discretion in terms of whether they want to exercise that power. The powers of the presidency are outlined obviously in Article 2, Section 2. And we're going to go into a lot more detail about what those express powers are in the second lecture for this week. Section 3 are the duties of the presidency. And the duties of the presidency are obligations that we place on the president. Not only do they have the authority to do these things, but we have an expectation that the president will do these things, that they don't have discretion. So, for example, the president in Article 3, it says that the president will give a State of the Union to a joint session of Congress from time to time. They don't have to do it every year, but they generally do it every year. And so that's an obligation that's placed on the president. The president also has an obligation to receive ambassadors from other countries to faithfully execute the law. And if they fail to do that, then they are not living up to the obligations of the presidency that are outlined in Section 3. Okay, that brings us to the last section of Article 2, which is Section 4. And Section 4 tells us that about the removal of the President of the United States. And so in Section 4, it says that the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. And I would not be surprised if some of you could recite Section 4, at least treason, bribery, or other high crimes and misdemeanors, because we've just lived through a time period where we had a president in a 4-year term be impeached for 2 different events. President Donald Trump, he's the only president that's ever been impeached twice, and he was impeached due to the scandal that came out of the Ukraine. And also he was impeached for his role in the insurrection that took place during the certification of the electoral votes on January 6th, which is currently being investigated by Congress, if you've been paying attention to the news. So anybody who's kind of cut their teeth on politics in the last, several years is pretty familiar with this Section 4. Now, I do just want to state that impeachment, that the president can be impeached, the vice president can be impeached, and it also says all civil officers of the United States. And the way that that's been interpreted by the Supreme Court of the United States is that, like, federal judges, including Supreme Court justices, they can be impeached. And also any federal officer of the United States, such as an ambassador for the United States, but also the Secretary of State, the Secretary of Defense, anybody who's working on behalf of the executive branch. Senators and members of the House cannot be impeached. That's the way it's been interpreted by the Supreme Court. But there is a provision in Article 1 for expelling a member of the Senate or for expelling a member of the House. So the House and the Senate can expel its own members, but they are not subject to impeachment. But the President of the United States is. Now, you might be wondering, well, what was going on in the minds of the framers? Why did they want to create a mechanism for the removal of the President of the United States or other federal officers? And it goes back to the idea that you wanted a check on the abuse of power. Here they are creating a single individual that's vested with the executive power. And they serve for a relatively long period of time, 4 years, right? And so they were like, we want to make sure that if that person who gets selected through the Electoral College basically abuses their power, there has to be some mechanism for removing that individual. And they talked about this a lot at the Constitutional Convention. And also, if you take a look at the Federalist Papers, you'll find that they talk about that in the Federalist Papers as well. In particular, A. Ham, again from Hamilton, but Alexander Hamilton, writes in the Federalist Paper that having a process for removing the president protects against the abuse or violation of some public trust. That we are expecting the president to defend the public good, and to act in the interest of the public. And if they abuse our trust, then we've got to have a mechanism to get rid of that individual. Benjamin Franklin at the Constitutional Convention went a bit farther. He was kind of very Benjamin Franklin-y at that time. He said, look, we're going to have a mechanism for removal of the president, and it sure beats the old school way that we used to get rid of executives, aka kings and queens. Chop off the head, right? The guillotine, right? Well, I guess that was after the ratification of our Constitution. But death, removal of the executive by death is often the way that kings and queens were removed from power. And so Benjamin Franklin said, hey, this mechanism is much better than the old school mechanism, which would be off with their head. Okay, so Article 2, Section 4 says that the president can be removed from office. But the power, the mechanism, the actual process for the removal is given to Congress, okay? And so when you look at Article 1, that you'll see that the power of impeachment and the power to try a president for removal from office, that is given to the legislative branch. And so the House of Representatives has the sole power of impeachment. That's in Article 1, Section 2. And Senate has the sole power to have a trial in order to remove the president. And that's in Article 1, Section 3. Now, students are usually like, what? What's the difference between impeachment, removal? We've had 4 presidents in U.S. history that have been impeached. Andrew Johnson, he was the vice president of Abraham Lincoln, and after he took office, he was impeached. President Nixon was not impeached, nor was he removed from office. That due to the Watergate scandal, that there were articles of impeachment that were voted on in the House and presented in the House, but he was actually they never actually voted. It never really got out of committee. They never had a whole vote of the House to impeach Nixon. Nixon saw the writing in the wall. He knew he was going to be impeached, and so he resigned. Bill Clinton was impeached, but not removed. Andrew Johnson was impeached, but not removed. Clinton was impeached because of the Monica Lewinsky scandal. And then President Trump was impeached twice, but he was obviously not removed from office. So a lot of times when students are like, impeachment, like, what is it? Like, what is the difference between what the House does and what the Senate does? And the way I like to explain it to my students is this way. Think about the impeachment as basically a grand jury, okay? And so what the House does is they look at the evidence and they say, hey, has this president engaged in treason, bribery, or other high crimes and misdemeanors? Let's look at the evidence and create articles of impeachment based on that evidence. And basically saying that based on the evidence that we have probable cause that the president did, in fact, engage in treason, bribery, or other high crimes and misdemeanor. And that's exactly what a grand jury does. What a grand jury does is they look at the evidence and then they indict somebody. They basically say, you know what? You're charged, you're indicted, you're basically charged with a crime. And that's what the House does. They basically say there's enough evidence here to charge you with a crime. Or in this case, not a crime, but charge you with treason, bribery, or other high crimes and misdemeanors. And then it moves to the Senate. And the Senate is like the trial. And so after this person is charged or impeached, indicted, the president, then they move to the Senate. And the Senate actually conducts a trial. So There was a trial for after the impeachment of Donald Trump over Ukraine. There was a trial after the impeachment as it related to the insurrection. And basically, there are lawyers making a case for why the president should be removed. And then the president has his lawyers, his or her lawyers, and makes a case for why this person should not be removed or convicted, right? So it's sort of like a trial. They should be convicted of the charges, or they should be not be convicted. They should be acquitted of these charges. And then the Supreme Court justice actually presides over the trial, and then the Senate votes in terms of deciding whether or not that individual should be convicted or removed. And as I stated, no presidents have ever been removed. And so keep that in mind that what the Senate does is they conduct a trial to see whether or not this person is guilty of the charges that they've been impeached with. But the only penalty, but it's a huge penalty, the penalty is removal. It's not like lock them up, throw away the key, put them in a jail cell. No, any criminal proceedings would not take place as a product of this. They could still be charged with the crime, but that is not a power that the House and the Senate has. Another way that another aspect of the removal of the president is the 25th Amendment. And after President Kennedy was assassinated, there were concerns about, like, when you lose a president to death or some other sort of incapacitation, we need to have a process for how to handle that death. And that's what the 25th Amendment does. And you can see it was ratified in 1967. And it provides a procedure for replacing the president or vice president in the event of their death, in the event of their removal, their resignation, or their incapacitation. And so actually following Nixon's resignation from the presidency, the 25th Amendment was applied, because that was really sort of the first application of it, where we were like, we had these resignations and we had to come up with a way of filling those slots. And under the Donald Trump presidency, there was some concern about his mental capacity and whether or not he was incapable mentally for doing the job. And there was some rumors about that the 25th Amendment was going to be exercised, and it never was. But it's another aspect of this, what to do as it relates to the removal of the president. Okay, let's move on now to talk about the sources of presidential power. Now, in your textbook, they talk about three sources of presidential power, okay? And on our final exam, and I know you don't want to be thinking about a final exam because you just got done doing your midterm exam, but there will be a question about these sources of presidential power on the final exam. And so your textbook talks about the constitutional powers, the institutional powers, and the way that contemporary presidents have expanded upon those powers, the contemporary expansion of presidential powers. In lecture, we're not going to talk directly about the institutional or the contemporary expansion of political powers. I'll leave that to you to read in the textbook. But we are going to spend time in the next lecture talking about the constitutional powers. But before we do that, I want us to talk about the specific categories of the presidential powers so that you're familiar with the different categories that these powers sort of fall into, particularly the constitutional powers. Okay, so that brings us to talking about the four powers that of the president that we talked about when I was doing the lecture overview. So in the next two slides, we're going to talk about the difference between expressed powers, implied powers of the presidency, delegated powers, and inherent powers. So let's get to that. Okay, so express powers, I think you're kind of familiar with, because we talked about express powers when we were talking about a Congress, but in Congress, we were sort of talking about them as the enumerated powers. But both expressed and enumerated, they basically mean the same things. And what express powers are the powers that are actually listed or enumerated in the Constitution of the United States. And these are powers that are exclusive to the president. Only the president can do these things. Just like when we looked at Article 1, Section 8, those were the enumerated or the expressed powers of Congress, and only Congress can do that, right? Only Congress can coin money. Only the president can, veto bills, right? That's an example of the expressed powers. In our next lecture, we're going to take a look at these expressed powers in a lot more detail. Another category of power of the president is what's known as implied powers. And these implied powers are the powers necessary to allow the president to exercise their expressed powers. So in a way, the implied powers are sort of similar to the elastic clause. Remember at the very end of Article 1, Section 8, when we were learning about Congress, that there was that the necessary and proper clause. And it basically says that the Congress can do anything it deems necessary and proper to bring these aforementioned powers into action. Well, the president has these implied powers as well. And these implied powers are spring forth from this thing called the vesting clause. And so in Article 2, Section 1, it says that the executive power shall be vested in the President of the United States of America. And so presidents have kind of looked at the vesting clause and basically said, any powers that I have, like I can, those are my executive powers, and I can, under my executive authority, I can basically do those things, even though they're not explicitly stated in the Constitution. So an example of that is that the president has the expressed power to appoint officers, federal officers, appoint justices, appoint members of the executive branch, like the Secretary of State. But there's nothing in there that says that they could remove those officers. Well, it's implied, right? That because executive power is vested in the president, they have the power to appoint. So it's implied that they have the power to remove officers as well. Okay, and so that brings us to delegated powers and inherent powers. So delegated powers are the powers that Congress gives to the president to implement law. And your textbook talks about how a lot of times that when Congress, writes a bill and then that bill is signed into law by the president, that there sometimes aren't a lot of details about how that law is actually going to be implemented by the executive branch. And that is the job of the executive branch, to basically execute laws. And so Congress basically delegates that power to execute laws to the president, and the president delegates that to the executive branch. And so the executive branch makes a lot of decisions about how to realize or implement that law, and that comes from delegated powers. So, for example, in the 1970s, Congress passed a bunch of environmental protection laws, the Clean Air Act and the Clean Water Act. But then they left it to the executive branch to basically implement that law. And so a good example is that President Nixon created the Environmental Protection Agency as a part of the executive branch in order to basically figure out how they were going to actually make sure that the air in the United States was clean, and how were they going to go about that process. A more contemporary example of that would be the Affordable Care Act. That when the Affordable Care Act was passed, there were a lot of details that were sort of missing from that law. For example, that the law said that insurance must cover some essential healthcare benefits and some essential package of healthcare, but it didn't actually specify what essential healthcare was. And so they delegated that power to President Obama, who then delegated it to the Department of Health and Human Services. And that was the department that said, okay, well, what are these essential healthcare benefits that all insurance companies must implement? And so that's a good example of delegation. And then the final is the inherent powers. And this is, it's not exactly like implied power, but it's sort of like there are some powers that are inherent to the presidency of the United States. And even though these aren't specified specifically in the Constitution, the president can still do these things. So it's sort of related to the implied powers. Inherent powers are basically deemed as the rights, duties, and obligations of the presidency of the United States. And that even though these powers are not specified in the Constitution, that they are they stem forth from, aspects within Article 2 that gives us a sense of what the whole rights, duties, and obligations of the presidency are. Also, in the presidential oath of office, it says, I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. And so it basically is telling presidents that they can use their own discretion, their own sense of what their inherent powers are, to preserve, protect, and defend the Constitution of the United States. And so it's been used for presidents to sort of expand their powers. And oftentimes these are expanded, and these inherent powers are sort of expanded during times of national crisis or national emergency. And the example that they use in the textbook is Lincoln. During the Civil War, Lincoln engaged in several acts that were not spelled out in the Constitution or sanctioned by law. And so, for example, in 1861, Abraham Lincoln suspended the writ of habeas corpus. That basically means that people can be detained and that they don't have to be told why they're being detained. And he said, that's one of my inherent powers. That he ordered martial law, that, he withdrew funds from the Treasury. Lincoln did a lot of things, and he justified those through his inherent powers that come through a national emergency. And he was very well aware that if people didn't like those, they could sue him and take him to the Supreme Court and, deem it unconstitutional. But he exercised those powers, and people did not push back and basically argue that he was acting unconstitutionally. And in fact, he was reelected to office, right towards the end of the Civil War. So read in your textbook about particularly Abraham Lincoln and other presidents and examples of the inherent power of the presidency. Okay, that's it for this lecture. And in our next lecture, lecture 2, we're going to explore in more detail the specific constitutional powers of the presidency, such as their military powers, their diplomatic powers, their judicial powers. Okay, thanks for paying attention, and I'll talk to you again soon.